This repeating now. They can all get over this thing.
Any mention?
Please, Lordship. I beg to make mention of item 13. 1-3.
Item
13, Lordship.
13. I'm there.
13.
Matter will come up after application, Lordship.
Premier by appellant. List this matter after 2 weeks.
Reply, Lordship.
Daily list item number 1.
Yes. You want to
lord,
make mention or?
I want to mention, my lord. My lord, this item number 789, my lord. In this case, in one of the case, Sir N.D. Shulai also is there. This criminal appeal number 55 of 25. My lord, I am praying if the matter can come up after the vacation, my lord. Mr. Datta from Guwahati, I think, was there.
Your
Mr. Nath is, I think, there in this case. R. Raj
Yes.
Roy. So I'm praying if the matter can come up after vacation, my lord.
On the 8th, Lordship, if it can come about the 8th, next Monday, that is.
why?
That's item number 7.
7.
Mr. Shulai is on bereavement. Mr. Shulai is on bereavement. His aunt expired.
Okay, who?
Yes, Sir N.D. Shulai
Okay.
so in bereavement. So we are praying if the matter can come up after 2 weeks.
Lordship, we pray if the matter can come up on the 8th, that is next Monday.
We'll make a effort, but we do not know.
Let it come on the 8th, Lordship.
7, 8, 9.
Yes, my lord.
7, 8, and 9.
8th, I think.
Yes, my lord.
Yes, good.
No, I'm talking about the serial number.
Oh,
Yes, yes.
7.
He is in 7.
You are in 7.
I'm on the
What's
7.
8 and 9?
8 also same
Nine,
case,
nine.
my lord. Common.
Okay. Together 7, 8, and 9. On pre-made by the parties. List this matter on 8.
Lordship,
Obliged.
deeply obliged.
I beg to mention item number 18, my lord. This matter can come up after vacation.
Why?
Some difficulty today, my lord.
I don't know what's this. what's
Otherwise, on
wrong.
the last occasion, my lord, I was ready for the hearing. My lord, I have already
I
done
think
hearing
last
on my
occasion
part.
you were not there, Mr. Sinkot.
Actually, I have done the hearing on from my side, my lord, but my lord wanted
Exactly. See, this is the problem.
Right,
This is
my
the
lord.
problem.
Forget.
You will do, half of the hearing.
Yes, yes.
The other side will respond after 2 months, 2 weeks, 2 months, 3
to
months.
difficult.
That is you.
Right.
You have to think of the court. So we are not superhuman to
understand, my lord.
to retain whatever is there.
Correct.
This matter, see,
If that be the case, my lord, may kindly fix it tomorrow, day after tomorrow, my lord. We can.
My lord, may fix it next week, my lord. Then in that case, next week, any date convenient to your lordship next week.
on preliminary parties, list this matter up to 1 week.
Obliged. I'd like to mention item number 12, lordship, of the main list, lordship. This is a criminal appeal, lordship. I'm praying if this matter can be taken up after vacation, lordship.
I'm there, my lord. No objection, my lord.
2 weeks.
Hello.
My lord, I beg to mention item number 4 and 5, my lord. Mr. Kishore is there.
Why?
My lord, we need some more time to prepare the case, my lord.
You have finished with
Well,
your argument?
no, well, I'm
No,
not
ma'am,
started. In
not
fact,
started.
6 is also connected. Mr. Senior Advocate.
And then number 6. These are all arising out of the same judgment. Same judgment.
So I'm praying if my lord.
You have not even started.
Not started. After 2 weeks, my lord, if possible.
2 weeks means it goes next year.
It's an old matter, of course.
Anyway, old matter. What is the case about?
My lord, this is under the POXO Act, my lord. POXO. Gang rape.
How many years?
10 years.
10 years.
10 years.
So it goes to next year.
Yes, my lord. Good.
On prayer made by Mr. S. Sengupta, learned additional PP, seeking accommodation on the ground that he is not ready to be heard in the matter. The same not be objected to by the learned counsel for the appellant. Matter is adjourned. This is same after 2 weeks.
6 also would be the same.
So 5, yeah, 4, 5, 6 there.
4, 5, 6. Public. Well, it's item number 10 and 11. Well, I prepared the other appeal, my lord. It's difficult for me to prepare 2 appeals on the same day. But this we can have it after vacations. 10 and 11 is connected, my lord.
On prayer made by appellant, this is matter after vacation. After vacation.
After vacations.
Fine.
Obliged.
Item number 1.
See, this matter was reserved for judgment
Yes.
for a long time. The reason we cannot pass the judgment is because there's a related
Other case.
involving same.
Yes.
So if we pass judgment here, it might have a bearing on it. So we had kept. But in the meantime, it appears that the other matter is not proceeding. So we'll release it from the reserve portion and tag together with the other case.
Take together with it.
Katuka number lah, tu. Number katuka ke case. Since this matter, this matter has been reserved for judgment. This matter has been reserved for judgment. However, there is a identical and similar matter pending for this court, which is also an appeal against the impugned order, impugned judgment and sentence pertaining to the same judgment and sentence involved in this case, for which the hearing could not be completed. Therefore, for sake of convenience, this matter is released from the portion of I and advocate. Judgment is reserved, close court, and to be tagged together with criminal appeal numbers.
Item number 2.
May it please, Your Lordship. For the petitioner.
Yes.
Your Lordship, I pray for some more time to file a paper book. Your Lordship.
Paperwork is here. Who's filed this paperwork?
Was being filed by the Lordship.
This is a paperwork.
Apologize, Your Lordship. Apologize, Your Lordship.
Okay. To start.
Your Lordship, my senior is on leg. Your Lordship. He's good number 2.
It's a BSF matter.
Yes, Your Lordship.
BSF.
Yes, Your Lordship. Lordship, if this matter may come up at the end of the board, then.
Dismissal.
Yes, Your Lordship.
Where is the impugned order of the first court against the order of the first court?
Lordship, it's in page number 36, annexure 3, Your Lordship.
Of the paperwork. This is bad. Yes, miss.
Lordship. Lordship, page number 11, Your Lordship, of the paper.
You tell us, what is the procedure before the force court?
Your Lordship, what had happened here was, Your Lordship,
Are the procedure conducted under the CRPC or IPC or Evidence Act? Or is it summary or?
Your Lordship, the accused was being charged under Ranveer Penal Code, Your Lordship.
Okay. What's the Ranveer Penal Code? It's more or less like IPC.
Yes, Your Lordship.
Yes, come. Yes, Mr. Deb, you are in this case. So,
So I actually had some difficulty, Lordship, with today was not fully prepared, but if they are ready, we're ready to do it, Lordship. So arising out of the General Security Force Court conviction and
before we proceed with the facts and merits of the case, we would like to know what is the procedure
Lordship,
usually employed, by the force court,
Lordship, yes.
and whether those procedures, at the end of the day, are they appealable, or whether you have to, you have to come by way of a writ.
Lordship, yes. Why? Because, Lordship, there are two parts, Lordship, to that argument. One is that, Lordship, this is the 4th round of writ petition. Originally, what had happened is, Lordship, this was a conviction. The incident happened in Kashmir, Srinagar, erstwhile Jammu Kashmir. Lordship, the trial under Rule 46 of the BSF Act, in a situation where a BSF employee, an officer, commits a civil offence, they call it civil offences, Lordship. While in duty, the BSF has the power to take over the trial than from a normal criminal court and do it under the General Security Force Court, Lordship. The first step is to have a record of evidence, Lordship, and thereafter the same is placed to the commandant, who places it to the IG or to the higher authority for either starting the GFSC proceedings or to drop it. Here, Lordship, ROA was conducted. Certain infirmities were there, which I'll come to it later on. Thereafter, Lordship, the Deputy Inspector General had convened the GFSC. It was conducted, and the petitioner was found to be guilty for an offence of murder, Lordship. Thereafter, what happened? The procedure under the BSF Act under 117, Lordship, Section 117, provides for a pre-confirmation appeal and a post-confirmation appeal. In this pre-confirmation is, Lordship, after the findings of the GFSC is delivered, they send it to the higher authority for confirmation of the sentence, Lordship. In between, the person concerned has a right to file a pre-confirmation petition. That opportunity was not given here, Lordship. In any event, once the confirming authority confirms the sentence and the punishment, a post-confirmation appeal is provided to the Director General of BSF under Section 117, Lordship. That remedy was availed of here, and interference was made by this Honorable Court, in as much as in this case what had happened, that instead of the Director General deciding the appeal, the statutory appeal, it was the Chief Law Officer who had disposed of the appeal. On the technical issue, Lordship, the matter was sent back for fresh adjudication by the concerned appellate authority, and again an order was passed whereby the original punishment under 302 and the sentence was upheld, against which, Lordship, there is no other remedy provided under the statute, and the only remedy to challenge that order, Lordship, the order by the Director General of BSF, is by way of a writ, Lordship. And concerning that this is a case where life imprisonment has been awarded, it has come before the division bench, Lordship. This is the third time. Originally it was before the Kashmir High Court. Thereafter, since the petitioner was a resident of Tura, a transfer petition was filed before the Supreme Court seeking transfer of the matter as well as his incarceration from there to Tura. Now he is placed in Tura, as the matter also was transferred to this Honorable Court, Lordship. In the first round of litigation, the grievance was that the appellate authority, which is the DG, had not decided the appeal within this stipulated time frame. Direction was passed to decide it within a stipulated time frame, Lordship. Thereafter, as I had said, Lordship, the CLO, the Chief Legal Officer, had dismissed the appeal, against which a second round of writ petition was filed before this Honorable Court. This Honorable Court was pleased to interfere on the technical point, send the matter back to the DG, and a fresh order has been passed, against which we are now before this Honorable Court, Lordship.
How a record of evidence is prepared?
Lordship, record of evidence is somewhat like a in the CR case, Lordship, what we have in a complaint registration case, like a pre-trial evidence, Lordship.
So accused will have a right, right?
Accused has a right to cross-examine. Then this entire record is sent to the concerned authority. A charge sheet is prepared. It is not the charge sheet under the CRPC, under the final report, Lordship. They have a separate charge sheet under the Act. It is provided under the rules. Then that charge sheet forms the basis of the proceedings before the General Security Force Court, Lordship. And after sentencing also, there is again a right, there is a procedure where
And how matter is investigated?
investigation is done by the police, Lordship. Then under section 46,
Then
and
what happens to the status of 161 statement recorded by police?
that entire charge sheet is nowhere in the record before the force court, Lordship.
No, what the rule says?
Lordship, the rule is otherwise
Matter
silent,
is tried on the basis of charge sheet
Lordship.
prepared and investigated by the state police.
Lordship, yes.
In such a case, what happens to the statement under 161? It is totally discarded.
Lordship, the entire charge sheet is disregarded because they have a separate charge sheet altogether under their own rules, which has separate set of.
And then they prepare this record of evidence on the basis of which investigation?
Lordship, it is a parallel proceeding, Lordship, if I understand correctly.
Parallel proceeding comes at the stage of trial,
Lordship.
when the trial is taken over, not before that.
Lordship, because here what had
had
happened.
to know how this matter is in investigation. If state police investigation is totally discarded,
Correct.
then how record of evidence is prepared in a court martial?
Lordship, and so far as this case is concerned, it appears from the record what had happened is after the FIR was filed, it was taken over by the state police. The entire investigation was done by the state police, and a charge sheet under the CRPC was filed before the Chief Judicial Magistrate in the concerned court
Then
there.
department claimed trial.
Department filed a petition to take over the entire trial. That charge sheet was disregarded. The same witnesses were again called for ROE, recorded, and again in the trial. That is what it appears from this record, Lordship. But of course, the BSF would be in a better position to clarify the exact procedure that they adopted, Lordship.
No, what is the procedure to be, what they have adopted in this case, we are not concerned right now with that.
Lordship.
We want to know what is the procedure prescribed in the rules.
Lordship, because when I have gone through the rules, it appears that that police investigation, whatever has come out of that investigation, is nowhere reflected in their rules, in the
It's
procedure.
okay, but then what happens
My
to
submission,
the very evidence which is collected by the state?
in my submission, Lordship, it cannot be relied upon. It goes, Lordship. Because the charge sheet itself is not part of the record before the security force court. So all those statements.
Now, if something is there in the record of evidence which is contradictory to the investigation of police, so accused cannot avail it.
And their trial also, they do it in a very closed manner, Lordship. Like in this case, there are about 17, 18 witnesses, all done in 1 week. And closed, Lordship.
This, again, this general force court,
Lordship.
where are the specific rules or the provision for that?
Under the BSF rules also it is provided, Lordship.
Yeah.
I have not made part of the paper book, but it's there under the Act and the rules, Lordship, in the
Yes, sir.
Act. BSF Act, Lordship, 19.
Section.
Lordship will see, it starts from section 46, that is where the power to take over the trial comes, Lordship.
First, we would receive. Must be some. You want to know the procedure followed by the.
Lordship, that is the rules.
I think there must be some. This is the act,
Lordship, it is there under
but
the
the
rules.
related procedure and rules are
Lordship,
not.
yes, it is there under the rules of this 1969, Lordship. I will just give it a minute, Lordship. Lordship will see BSF rules, chapter 4 onwards. Chapter 4, rule 41. Chapter 4, rule 41. Rule 41, Lordship, talks about the choice. The heading is, Lordship, chapter 4, choice of jurisdiction between security force court and criminal court.
Chapter 6.
So here they have the power to choose, and thereafter the procedure starts from 43, Lordship. Offence report, charge sheet, chapter 6.
This is chapter 7.
Lordship, chapter 6 and 7 is the entire. It starts from chapter 6 is also relevant because it talks about the pre-trial part, Lordship, from rule 43. Lordship will see rule 43, it talks about an offence report.
Yes, offence. Offence report would mean the.
It is similar to an FIR, but they have a standard format for it.
Okay.
And thereafter they talk about a charge sheet. This is not the charge sheet under the 154 final, 173 final report. This is a separate charge sheet altogether. Then hearing on charge under rule 45. And 45A, depending whether he is officer or enrolled person, Lordship.
Is there any provision for you to be defended?
Lordship, yes. Defense assistant can be allowed, advocate or otherwise.
You have a bail then.
Lordship, you have availed. It starts from Rule 43, Lordship.
You see, the only concern, or rather the query that this court has is this, that if these proceedings have finally culminated in at the appellate stage by the DG, whatever,
Lordship, yes.
sentence confirmed.
Lordship,
Now, if that sentence is appealable,
Lordship.
then whether writ court,
It is not appealable at all, Lordship.
if it is not, even if it is not appealable, it should be appealable, because what happened is the writ court would not go into evidence.
Lordship, yes.
See, the writ court would look only, as far as procedure is concerned,
Lordship, yes.
whether due process has been followed, whether principle of natural justice has been violated,
Lordship, yes.
whether it was arbitrarily, all those.
Lordship, yes. The procedural
Then
part, Lordship.
whether at this court can relook at the evidence and say that this is where you are wrong, you should not have come to, had you appreciated the evidence
Correct,
properly,
Lordship.
this decision would not have been made. Those things, as in an appellate.
In a normal criminal Lordship,
in a
yes,
common-
because in this situation, Lordship, perhaps your Lordships can only give a finding of perversity or otherwise on the evidence. May not reappreciate the entire
Can we do that?
Lordship. But here, that is the unfortunate, because in a normal criminal appeal, in a murder case tried by the Sessions Court, first appeal, a full appeal lies under the High Court, and thereafter that is, they can take it to the, but in the BSF, under the BSF, Lordship, once the DG confirms the sentence, in my humble submission, there is no court which otherwise has the power to relook into that entire evidence.
Have you filed any authority on the power of the High Court under 226?
Lordship, at this stage I have not, but I can place, there are authorities, Lordship, where even perversity can be looked into, but not a minuscule reappreciation of the evidence.
Exactly what is our concern.
Lordship, yes. Because the fact remains, Lordship, because what happens is the DG can also confirm a sentence of withdrawal of, non-grant of increment or withholding of promotion. In those situations, the entire facts and circumstances are different. At the same time, under the same powers, Lordship, he can confirm a death penalty or a life imprisonment, like in this instant case. The fact remains that certain evidences have led to a situation where the personal liberty of the particular petitioner is affected, Lordship, for his whole life. But at the same time, Lordship, under the Act, there is no other way to challenge it, Lordship. Whether this order by the DG would be appealable, can be challenged under the Code of Criminal Procedure, Lordship, because the Act does not provide so.
That is why, you see, again, if I repeat myself, you see, the point is, firstly, the issue of maintainability. Next is whether the sentence can be interfered with by this court. If that is the case, then it would assume the character of an appellate court.
Lordship, yes.
Whether that is permissible or not.
Whether it would assume the character of a 378 or a 372 court, Lordship, that I have to look into. But whether this honourable court has the power to entertain, to look whether the petitioner has the right to avail or challenge this order under 226, Lordship, there are judgments which allow it, Lordship.
There is no problem with that. 226 extraordinary jurisdiction.
Lordship, yes.
It's discretionary in nature.
Lordship, yes.
So if you can, even in cases where regular appeals are maintainable, you can show that something has been done by resorting to any practice which is not allowed by law. Maybe they are also not always, maybe
Discretionary, yes.
But then, leaving apart that, tell us what is an offence under BSF Act? What is an offence under the BSF Act? Now, if you can't, you are referred to Rule 45,
Lordship, yes.
the charge sheet.
44, yes, charge sheet.
Just read it.
Lordship, charge sheet, where it is alleged that an officer or a subordinate officer has committed an offence punishable under the Act.
Yes, under the Act, in which Act?
Now, under the BSF Act. Now here, when they say offence under the Act, they talk about two separate types of offences, Lordship. One they say offence under the Act per se would mean the offences which are laid out under the Act, like withholding of increment, dismissal from service, etc. But there is also a section which says, Lordship, that offences under the Act would also mean civil offences.
Where is that?
Lordship, that
You have led us to section.
Lordship, yes, section 46 of the Act. And civil offence is defined in 2D. If Lordship will first see 2D, it says civil offence is an offence which is triable by the BSF court.
By criminal code.
By a criminal court, Lordship. And civil offence has been otherwise defined in 46.
What is an offence under there?
Those are the offences, Lordship, this regular service kind of related offences, Lordship.
So it means all offences falling under IPC will be civil offence. Yes,
Lordship, yes. Under any law, in fact. If the offence is one which would be
Look at section 47.
Lordship, these are the offences, the situation under which they can.
What is the charge against him?
302.
No. The fact.
The fact is, Lordship, that he had shot a fellow officer while on duty. So that is why under clause A, they have
Under clause A.
Yes. Had it not been on active duty, then probably it should have been tried by they could not have taken it.
Devote something. Dr. Musika, do you have the proceedings with you? You're not privy to the proceedings.
The entire proceedings I have not. Only what has been supplied through what was relied upon by the court. The evidence I have not.
You filed your counter.
Yes, ma'am.
I think proceedings must be there.
The record was called for, if I am not mistaken. The entire records are before this court.
The court was called.
Lordship, yes.
Just when it courts. Okay, records, low court records.
The proceedings are with us, madam.
Huh?
The original proceedings are with us.
Because I think in due course we will have to go through the proceedings.
I'll place it.
So, Mr. Deb, you're not prepared today.
Lordship, I was requesting for some time too. Lordship,
You just consider the query of the court.
Lordship, yes. I'll place this,
Then
authorities are there. With regard to the maintainability, Lordship, I don't think there is any such dispute. With regard to how far this Honorable Court can go into it, Lordship, I'll just try to.
the extent of interference by this court is.
226 with the same parameters, my lord. It's not an appeal under CRPC, my lord.
That is exactly the.
Because that appeal is provided under the statute that has been already been taken
So
care
we'll
of.
exercise the power of judicial review.
Judicial tribunal.
And what are the ground you have taken? My principal grounds?
Lordship, principal grounds, procedural lapses, and complete perverse appreciation of evidence.
So that we have to go through the evidence and see whether there is perversity.
Lordship, yes. I'm taking a plea that it should have been a case of 304, not a 302 case. That is,
Can it be done?
But
Lordship, it can be done.
is there a provision for alteration of charge?
Lordship, yes. Your Lordship may quash the entire thing also and send it again for reconsideration.
The writ petition. To what extent you can do it? To what
Because-
extent you can alter charges?
Lordship, in my humble submission, it can be done, Lordship.
If you say that your case will be based on the plea of perversity, then
If not, that's why I said twofold, Lordship. One is the procedural part, and the other part is that even on a wholesome appreciation of the evidence, there was no 302 case, Lordship.
because you are maintaining two stands.
Lordship.
Publicity, Lordship will only see whether there is any evidence or not.
That is what
Sufficiency
exactly.
of evidence.
See, see, like what we understand, we do not know, subject to.
I'll place it. Guwahati High Court is a very elaborate
If we
judgment.
find that the view taken by the force court is a possible view, there is no question for us.
My lord.
Then if you say
Exactly, my lord.
that view could not have been taken,
Yes, ma'am.
the evidence is white and the
Yes.
findings is black, then definitely we. That is
But of course,
Yes, ma'am.
2 plus 2 is 4. They said 2 plus 2 is 5. We interpret.
so after vacation, then?
Lordship, please.
This is a case, my lord. He was posted in Srinagar airport, defense airport, my lord. He shot at his fellow colleague 9 rounds, my lord. Killed him on the spot. And then he abused him. And after killing him also, again, he goes back to barrack and says that I killed that anti-Indian and all that. So many things.
Their entire case is based on my extrajudicial so-called statement. And I have nowhere mentioned anyone's name in that
What
statement.
evidence would be admissible and what would not be admissible is guided by what? The provisions of the rules itself.
Lordship, the rules itself. What is only admissible is the ROE, Lordship. They don't consider those 161, 164 other materials at all.
Now, then you say that your statement was the main
Lordship, yes.
basis on which you were
Lordship.
convicted. Then if there is no bar in taking this thing, cognizance of that, if there is no bar in admissibility, then which way it is?
No, whether that itself was enough to convict me for murder, Lordship, that is the...
On premium by the appellant, petitioner, this is matter of vacation.
Lordship.
Item number 15.
Bereavement with Sir Sulai's security. So I had said
Oh, this is, yes. I think he has sought for time.
along with the other connected
It is
matters.
fixed on?
After 2 weeks.
Can it be on 15th, my lord? A date may be fixed because I have to come from Guwahati, my lord. Today I got stuck for 2 hours at Khanapara.
We have listed after 2 weeks, I think.
15th may be fixed, my lord, if possible. A date. Today is
But
1.
even, you see, even if we list it on 15 also, practically it may not be able to be completed.
Last working week, yes.
Because it those to be very last.
After 2 weeks means it will become after holiday.
Vacation, most probably.
After vacation.
So let it be after vacation, my lord.
Yes, after 2 weeks, after vacation.
2 weeks.
My lord.
Because there are, I think, yes, 2 or 3 connected matters.
Three matters are there.
So those two, I think he has sought for accommodation.
Yes, my lord. Okay, my lord. No problem.
Please, Your Lordship. Lordship, I beg to mention item number 6, my lord. I've been from the other side. Matter may kindly be taken up after vacation, my lord.
I'm appearing for respondent 3 and 4, Your Honor.
Who's for the?
1 and 2 is represented by union. Sir,
Is that cantonment board?
Cantonment board. 3 and 4 are cantonment board. After vacation, my lord.
On premier by the petitioner, matter sit after vacation.
Much obliged.
May it please Your Lordship. Your Lordship, I beg to mention item number 4. Your Lordship, Mr. Shulai is in bereavement.
You have started with this?
My lord, on the last occasion, my lord has asked me to bring some clarification where I filed an objection against the inquiry report under a certain provision. Yes, my lord.
Have you got any decision?
My lord, I have got a decision from Allahabad High Court wherein they preferred the same plea, my lord, but that was during the pendency of the trial, my lord. So they have preferred under section 53 of the Act because that the trial was pending. But with regards to the inquiry is concerned, my lord, there is a judgment again from Allahabad High Court where it specifically stated that the inquiry is different from that of the what is pending because that the application has been filed at the belated stage, my lord. So that is different. So that judgment I have, my lord.
No, what you see, now the question here is, inquiry has been conducted in the midst of the proceedings of the appeal.
Yes, my lord.
Now, the appeal is still pending.
Correct, my lord.
Inquiry conducted, done, report filed. Now, how do we reconcile the fact that the inquiry has to be brought back, to the proceeding in the appeal?
Yes, my lord.
That is the question. Whether it can be done or not, whether it has to be taken separately, all those questions have to be answered.
My lord, with that, I have a slight clarification, my lord. My humble submission is that, my lord.
Anyway, but Mr. Shulai is not here.
Yes, my lord.
So we'll take it up next week then.
Yes, my lord. After 1 week.
Made by Ms. Seeking accommodation on behalf of Mr. Shulai, who is indisposed. That is adjourned. To not objected to. This is matter to 1 week.
Obliged, Your Lordship.
Highly obliged, my lord.
Your Lordship, I have similar prayer for item number 13. Your Lordship, this is a joint prayer along with the appellant, Your Lordship.
Objection, Your Lordship.
13, Your Lordship.
After vacation.
Obliged, Your Lordship.
My lord, item number 2, my lord. Mr. Yobin is for the petitioner. Here I'm being led by Mr. Shulai, my lord. As my friend has submitted, my lord, on bereavement, I'm praying for adjournment, my lord.
Yes.
Mr. Yobin is also not in town, my lord. Joint prayer, my lord.
After vacation?
My lord, it can after vacation.
After vacation, payment with parties.
My lord, item number 3.
What about this item number 9?
My lord, this point, Lordship has heard me at length. My submission has been concluded, and Lordship fixed the matter after 3 weeks.
9 and 10 not same.
No, item 3, my lord.
My one is item number 3.
No, I'm just asking about item number 9. See, adjournment was...
Item number 8, my lord.
No, item 10, just now. Item number 10.
9, 10, 11 are connected, Lord.
That's what I was
saying.
9, 10,
8 to 11.
9 is also same person.
Same issue,
yes.
9, 10, 11.
9 is not, my lord. 8 is not filed by me. 9 and 10 are filed by me.
Yeah.
But it's a connected issue, they said.
9, 10, 11 same.
Yes, my lord.
All these matters, my lord, the question is that the petitioners the respondents who are having 18 months of diploma, my lord, in the education. So the petitioners have said that 18 months of diploma is not a valid qualification for appointment as primary teacher, my lord. This issue has already been settled by Honorable Supreme Court, my lord, that holding that 18 months of diploma is valid. Whenever a lordship will have we'll place those orders.
Anyway, that when it comes to that, merits has to be looked into. But what I'm inquiring is, you see, when for item number 10, adjournment has been sought for by Ms. Kulni.
So all three matters will be adjourned, my lord. All three matters are connected. Issue is common.
That's what I said. 9, 10, 11. 8, 9. Oh, sorry. 9, 10, 9, 11. Corrected.
Yes.
9, 10, 11.
8 also.
Number 8 is also connected.
Oh, 8 you are there.
Yes.
So next week or after vacation then?
Next week also subject to lordship convenience. Next week also subject to lordship convenience.
There's no urgency in this matter, I'm afraid.
Because in 10 it goes to vacation. After vacation. After vacation. 8, 9, 10, 11.
Yes,
Yes,
sir.
That's selection method. Select.
My lord, item number 3.
Number?
Item 3, my lord. My lord, here I've just been engaged, my lord, in this matter. For item 3, for respondent 3 to 5, I will also be there along with my brother here, Mr. Paul Sinkon. So, my lord, I will be requesting some accommodation because I've just been engaged. We need to give a reply, my lord. There are certain aspects also we would like
Is
to.
that Assam Rifle matter?
Assam Rifle matter. Lordship has heard the matter.
It's not, my lord. It's not an Assam Rifle matter, my lord. It matter concerns the school.
Anyway, whatever the case.
My lord.
So that just say Assam Rifle.
My lord.
So
because my lord, that would be one leg of our
some
argument.
association, but nevertheless.
My lord,
well, matter is different.
Being identified as Assam Rifle matter has created the whole mess which has brought us before my lord.
They are teachers of the is this
They are
ARPS.
They are teachers of a ARPS, which is a private entity, and it has got nothing to do with Assam Rifles with regards to finance or funding. My lord, be as it may.
Whatever the case, this is already a settled matter here. This court in a previous matter,
my lord,
has granted them the benefit of the 6 pay commission.
Right, right.
So what's the problem?
My lord,
friend is not properly
The
instructed.
only constraint, as if I can understand correctly, is fund constraint.
My lord. My lord, not just fund constraint. My lord, there are aspects. My lord, I need some
You appear
accommodation.
for whom then?
I will be appearing for the school management committee, along with him.
So now he said he has been engaged newly, my lord. So I'll also take some instruction.
So he's just making you stand by his side.
No, my lord. My lord, we'll see what solution we can come to, because this is something, if the school gets closed.
See, the point is this, Mr. Kera, you have rightly said the correct thing.
My lord.
In as much as in the earlier round of litigation,
my lord,
there was some sort of a compromise, arrived at between the parties.
My lord.
When the school has conceded to a certain extent,
my lord,
for which even the petitioner has also made some concession as far as their areas, whatever is concerned.
My lord,
I understand correctly,
I've seen that issue is, my lord, that the Assam Rifles, the department, they have committed a mistake. If I have to stand from the point of view of the school and say, Assam Rifle had no business to come and contest the case. It was I who had to contest that case. So now, because of some mistakes and errors which have happened, if the sword has to befall on me, so I want to present who I am and what is my stand in this. So, my lord, I seek some accommodation.
It's okay, that would be there, but then we'll have to look into the core issue and see.
My lord.
Yes, Lordship has heard me at length on 25th September. It is concluded. My colleague has to reply, my lord. If my colleague is entering for first, I am not objecting. Lordship may fix the matter next week. Conclude the hearing. It's a cover case.
My lord, I don't want to stand and seek time again. My lord, let it come up after vacation. I'll take some time to crunch the whole, because this is not the first round of litigation, my lord. The matter has travelled through courts after vacation, my lord. Any date.
I have objection.
It's a very old matter.
It is 22 matter, my lord. I understand, but
what happened, my lord? They will seek time, and Lordship direct them to pay the arrears. They say there is no fund, I will shut down the school. That happened to the 6 pay commission matter also. Now 7 pay also now denying, and Lordship they are taking time again and again. And Lordship, if proceeded my argument, direct them to pay, they said I will shut down the school. Lordship is a cover case. My friend may take time. Subject to Lordship, give me the second, my lord, date 10, 11. Lordship may fix the matter. and reserve the judgment.
Let it come up after vacation. Why I'm saying, my lord, in case, my lord, the result of this case, my lord, is not in favor of the school. In that event, my lord, the school has to be shut down. There is no other option.
My lord, that is why they are pleading.
Because the fund, my lord, we are not receiving any fund. There is no budgetary allocation.
My lord, I will also be filing an affidavit. My friend is saying the right
They
thing.
cannot file an affidavit.
To bring the financial record before the court. My lord, it may be, it is part of, it will be part of my argument. Court may not look into it.
Not at this stage.
Exactly. They file a detailed affidavits.
My
Getting
lord,
concluded from my side.
matter may come up after vacation, my lord. It will enable us to prepare and present the case, my lord.
Are you getting your salary?
They are paying the salaries, writ petitioners, but those who are retiring, their benefits are denied.
My lord, I think the petition also needs to be amended because there are many people who have retired from the service. They are in fact still party in the case. They have to amend the writ petitions.
The amendment is not required. They entitled. They serve the service. Some of them retired, but they are seeking for 6 pay benefits. So even if they retired, they entitled. So there is no question of amending the cost title.
My lord, those people who have already retired, and moreover, my lord, there are 2 sections of people. One are staff, and the others are teaching staff. Others are normal staff of the school. Now, both the staff and teaching staff and non-teaching staff, my lord, they are clubbed together and file the writ petitions, which also, my lord, is not maintainable as far as
that was already decided earlier on our litigation.
The claim is concerned, my lord. That claim may not be maintainable.
That is already decided. Dear Supreme Court decided.
We'll go into this matter after vacation, because practically, even if I allow them 1 week or 2 weeks, it makes no difference, because thereafter, by the time judgment is passed, it will come after vacation only.
My lord.
As long as you're still getting your salary, so it's okay.
Well, salary, there is no impediment. The salaries are being paid.
Those who have retired, benefits are not
even those who have retired, they will still get the present benefits. Later on, if matters, if situation change, they will get whatever areas that is due to them.
Lordship may keep it as a part of it. I've already argued on.
I cannot accept your, if you are there, file your Bakadama, okay. But Mr. Sunkon is he is the counsel on record.
My lord.
He is representing
my lord.
If he has been disengaged, that's a different thing.
My lord, we'll both be there. We'll both be there, my lord, and we are filing our Wakalatnama in the course of the day today.
You can you can seek genuine ground that you are newly appointed.
I agree, my lord. My lord, only to bring a case to a logical conclusion.
That's a different thing. Whether you assist him or he assists you, that's a different thing. We don't know. But you cannot come and say that I've just been newly engaged and
my lord, we only seek accommodation only once. Anyway, give us time until after vacation, my lord.
You file your power.
We will, my lord.
On premier with the parties by the respondent. By Mr. N. Sincon, the counsel for respondent number
3 to 5.
3 to 5. Matter is adjourned. This is you after vacation.
Lordship may keep the matter part heard, since I've already argued.
Yeah, matter is only part heard.
Part heard.
Matter to be further hearing in this matter to be taken up after vacation.
Yes.
Highly obliged, my lord.
May I please, Your Lordship? I beg to mention item number 7. Your Lordship, we need some more time to file our written statement, Your Lordship.
Matter has been heard.
Matter has been heard. Parties have been heard. We were required to file our written arguments. But again, my friend is taking time.
Have you filed yours?
It's ready. We'll file at the same time, my lord.
Why file the same? Because you have to give him an advance copy.
Because the matter is already heard, so there's no question of.
But have you cited any authorities?
No, nothing beyond the oral hearing. Nothing beyond the oral hearing.
I have submitted my lord. Respondent number 1, I have submitted my written argument.
You have submitted.
Your Lordship, my argument is ready with the Lordship permission
and who are you?
Your Lordship, respondent number 2.
Who is respondent to? Owner. Oh. This is not a case where it has gone ex parte against the.
No, ma'am.
You're a driver.
I'm
from the driver.
Driver, owner,
I'm
claimant.
I'm claimant.
Your challenge is on quantum.
My lord, less on quantum, more on the fact that the driver did not possess a license, did not possess any license on the date of accident. But in spite of that undeniable facts, we were not released from liability or given pay and recover.
Okay, that was also
that was also not given to us.
You'll have to take it after vacation then. I can't. Even if you file your written argument, I don't think you'll be able to finish the judgment. Pre-made by Mr. Learned Counsel for the respondent number 2.
Respondent number 2, Your Lordship.
Yeah, sure, I got to. Miss Learned Counsel to the respondent. You're respondent 3. Respondent 3. Driver has filed the written argument. Similarly, Mr. S. Jindal, Learned Counsel for the appellant, has also filed the written argument on behalf of the.
We have not filed as yet.
You're not filing today?
No, my lord. If Lordship allows me to file along with my friend, my lord.
Tata, my thoughts about Mr. James. Mr. has sought for time. Mr. Learned Counsel for the respondent number 2 has sought for time to file the written argument. Well, you have filed earlier, isn't it? It has gone on record.
Not, it has not gone, my lord.
Mr. Esplanade, Learned Counsel for the respondent number 3.
1.
Number 1 has also submitted that the written argument has been filed. On pre-made, this is matter of the petition.
Lordship, if I can mention item number 12, my lord. This is also an MSc appeal. This matter, my lord, the hearing had started quite some time back in July. Lordship had expressed Lordship's mind that possibly parties can explore mediation to try and settle this matter. Matter had been referred to mediation, but unfortunately, my lord, this was July itself. Unfortunately, my lord, mediation did not yield any result. So now today it's been listed again for hearing. Other side, my lord, the respondent 1 is Mr. Hazarika, but I don't think he's present in court. I can't see him, my lord. So maybe after vacations, this matter can be taken up, my lord.
On pre-made, this is matter of the petition.
Obliged.
Excuse me.
May please, Your Lordship. Your Lordship, I beg to make a mention of item number 5, Your Lordship. I humbly pray, Your Lordship, kindly this matter may be listed after vacation, Your Lordship. We have already taken consent from the other party also, Your Lordship.
Lordship, I am for the respondent 1 to 4, Lordship.
After vacation.
Hello, Lordship.
Item number 1. Please, my lords. My lords, this is a bail application being moved by the wife of the accused. This in NDPS case number 8 of 2025. He was arrested on the 3rd of September 2025, my lords. And our contention is that nothing incriminating has been obtained from him. He was sitting and having tea at the tea stall. And from there, the police came and nabbed a bag which had contraband substances. And that was of commercial quantity. But we deny the fact that it was ours. That's the case.
What is the stage of the case?
Your Lordship, investigation is still going on. Charge sheet has not yet been filed.
Not yet filed?
Not yet filed, Your Lordship.
When was he arrested?
On 3rd of September.
3rd September.
85 days, my lord. Till the 27th, it was 85 days. So it is
87
days, 88 days.
Your Lordship, the statutory period is 180 days in case of commercial quantity, Your Lordship.
180 days?
180 days, Your Lordship. The matter is still under investigation, Your Lordship. And our contention is that, Your Lordship, as per the preliminary complaint which we filed before the court, that almost 2 kgs of crystal meth was recovered from his backpack, Your Lordship. And he was walking on Umtru bridge. He was crossing the bridge. We had specific intelligence and he was apprehended in presence of 2 independent witnesses, Your Lordship.
But you were saying it was in a tea stall?
It was in a tea stall, my lords. That is what. It is not mentioned exactly from where was he nabbed and where the bag was taken.
Then, of course, we have looked into the papers. There.
Yes, my lords.
You produced the case diary?
Your Lordship.
Miss Nana Counsel for the petitioner has submitted that this application with prayer for grant of bail has been made by the
Wife of the accused.
wife of the accused, Dilip Das, who was arrested in connection with, what's the case number?
My lords, 8. NDPS case number 8 of 2025.
PS. Is it Shillong?
Yes, my lords. Ribhoy district. Meghalaya.
So under section 21 and
29.
29, yeah, NDPS pending before the court of the. But investigation has not been completed.
No, investigation is not yet.
Why was it registered as only as 8 of 2025? Should have been the police station.
Yes,
you know.
my lords.
Most probably this is the GR number or something, Your Lordship.
This should be.
I'll seek instructions on this, Your Lordship.
No, what's this? Custom NDPS case number so and so and so?
This is the seizure case number, Your Lordship.
Seizure case?
Yes, Your Lordship. This number is allotted by the department.
But you see, where's the FIR?
My lords, we have the complaint. We've annexed the complaint, my lords.
Annexure 1.
Yes, my lords.
So this complaint is usually the FIR, isn't it?
Yes, Your Lordship.
It would have been presented in court.
Yes, Your Lordship.
Okay. Presented in court, but the investigation is taken up by the customs.
Yes, Your Lordship.
Not the regular police.
Not the regular police.
So this is the reference is this at page 12. This is
Yes, Your Lordship.
custom
Yes, my lords,
NDPS
yes.
case numbers 3,
Three
so on and so
C.
forth. Is it so?
This is the reference number.
My lords, yes.
So he was arrested in connection with this case.
Yes, Your Lordship.
And where does that NDPS 8 comes from then?
My lords, that is what is mentioned here in. My lords, this is the. My lords, what is mentioned in para 2 of my application is that the customs headquarters, one Shri Saurav Kumar Pandey, Inspector, Customs Headquarters, has filed this. After his arrest, said police filed a complaint petition number this in the court of the Special Judge Nongpo, Ribhoy, Meghalaya, which is registered as Criminal NDPS case number 8 of 2025.
Yes, this is the one.
This is the one, my lords.
No.
Court has recorded the investigation.
In connection with custom NDPS case number 3, page 3 ini para 2. Wherein on the said complaint being presented in court, the same was registered as criminal NDPS case number 8 of 2025 before the court of the special judge NDPS and a bracket NDPS, Nongpo, Ribhoy district. Mr. Larrett, counsel for the respondent, Union of India, has accepted notice on behalf of the opposite party. Stop. At the outset, this court is desirous of the case diary to be produced so as to be acquainted with the status of the investigation. Accordingly, let the case diary be produced on the next date fixed. Can you do it on 9th? My Lordship. This is matter on 9th.
Grateful, my lords. Item number 14.